All right, why don't we start again? Are we on? How about now? Can you hear me? All right. Well, why don't we start just because we've got a lot of material to get through here so people can file in. So we're talking about not guilty by reason of insanity. And it's an infrequently raised defense, raised in 1% of all felony cases, and infrequently successful. So contrast this to the public perception that the insanity defense is raised frequently and almost always successful. Instead, rarely raised and only about 25% of the time is successful. Now, here's the one take-home message from this presentation, is that if you have an NGRI case, do a bench trial, because juries, because of their misperceptions about the insanity defense, rarely come back with a verdict of insanity. In fact, a large number of the cases that are successful is actually where the prosecution stipulates to the finding. But there are times, though, as I mentioned before, where a bench trial where the judge will come back with a finding of insanity. A judge is much more likely to apply the law to the facts as opposed to a jury. So there's been a number of different NGRI standards developed over the past few centuries. These all came from England. The wild beast test came from early 1700s. And there's been different models for how do you view the insanity defense. Where do you draw the line at? And we don't have time to go through all these here. But the first example, or the first, yes?
Going back to your last,
That one?
as far as the waiver of jury,
Oh.
what would be your opinion then as far as waiver of jury if you're dealing with the battered woman syndrome? It's a fairly complex defense, isn't it? I mean,
Yeah, you have to show that, I think it's actually a Supreme Court case called Goff that talks about the testimony. It's a three-prong.
right, test.
Yeah. I mean, it's a similar concept, you know. It's more, did they have battered woman syndrome that helped them meet the elements of self-defense, of a perceived self-defense. Again, this is just pure speculation, but my guess would be, you know, jurors would bring their own, you know, misperceptions about battered woman syndrome that may be a factor, where, as opposed to a judge is more likely to apply the facts to the law. That's my short take on that.
I'm sorry, didn't you? Thank you.
Yeah. All right. So the first example of a psychiatrist rendering expert testimony was in 1760, the trial of Earl Ferrers, who pled insanity under the irresistible impulse test but was unsuccessful, and he was hanged. The McNaughten Trial, most famous insanity standard, 1843. Now, Mr. McNaughten was from Scotland, and he had a number of paranoid delusions, and he stalked Prime Minister Robert Peel, who here we see here. Peel is noteworthy because he started the police force in London, and so that's why the police officers in Britain are called Bobbies, because his first name is Robert, or they're called Peelers because of his last name. So McNaughton, paranoid, tried to kill Peel, instead shot the man next to him, the unfortunate Lord Drummond. So McNaughton pled insanity, and he was examined by several psychiatrists who did personal interviews. They all testified at the jury trial that McNaughton was insane. Several other psychiatrists did not actually speak with McNaughton, but just observed him during the course of trial. And for whatever reason, they also testified that McNaughton was insane. Justice Tyndall, the presiding judge, told the jury that the whole of the evidence is on one side. And the jury did not even retire to the jury room. Instead, they put their heads together in the jury box, and after a 3 or 4 minute conversation, came back with a verdict of insanity. So this led to public outrage in Britain, and this led to Justice Tyndall convening a panel of appellate judges to consider what is the appropriate standard for insanity. So the point here is that McNaughton was not tried under the insanity standard. Rather, the McNaughton standard is a result of the appellate review of McNaughton's insanity verdict. And they actually combined a couple of older standards, the wild beast test and the right from wrong test. But basically, the McNaughton standard is a mental illness where the person does not know the nature and quality of the act or the wrongfulness of the act. And what's new with McNaughton is prior standards, the standard was, could the person tell right from wrong in general? With McNaughton is, did they know the wrongfulness of the specific offense? That's what was new, which of course makes sense now. There's been different standards in the U.S. as well. You might be familiar with the Durham standard, which is a product standard. The person could be legally insane if the offense was the product of their mental illness, a very low standard. And the Model Penal Code standard from the American Law Institute. So now we have Ronald Reagan in spring of '81, shot by John Hinckley, pled insanity, was found insane, of course led to the same outrage in this country as it happened in the McNaughton case. So at least the federal jurisdiction changed the insanity standard. They made it tougher. They inserted the word severe in front of the word mental disease or defect. It's a strict McNaughton. And they also then heightened the standards for a post-NGRI release. In fact, I believe Hinckley was just up for release in recent years. All right, so present day standards. So I think 4 or 5 states have abolished the insanity standard. Of the 45 or 46 states that do have it, all have a strict McNaughton, which is what Ohio has, which I'll talk about in a second. And then 1/3 of the states have a second route to insanity, this irresistible impulse test, that the defendant could not refrain from the offense due to his mental illness. In Ohio, we had both until 1990. Now we simply have a strict McNaughton. So here we have Ohio, a presumption of sanity. So the defendant bears the burden of proving insanity by a preponderance of the evidence. The standard is threshold of the severe mental disease or defect that then caused the defendant to not know the wrongfulness of the offense. So whenever we do an evaluation, we focus on their mental state at the time of the offense. The present mental state is not an issue. That's competency. So we're trying to go back, look at the facts of the case very carefully, turn back the clock, and reconstruct the defendant's mental state at the time of the offense using mostly records and also accounts of the offense. So the defense enters a plea of insanity. The court will then order a sanity evaluation at one of these 10 or 11 Ohio forensic centers, such as the Summit County Psychodiagnostic Clinic. And then either side, either prosecution or defense, is free to obtain second or third opinions. Of course, the defense can obtain as many as they want and are able to fund. The prosecution usually is entitled to at least one prosecution-arranged evaluation. This is the State v. Hicks, talks about the sound discretion should be used by the trial court to determine the number of sanity evaluations, and the appellate review is an abuse of discretion standard. So for the mental health professional to do the evaluation, they need to know the actual language of the standard, determine the facts of the case, and apply the facts to the standard and develop a well-reasoned opinion here. So we determine the facts of the case by primarily looking at records. We want to look at the defendant's past medical records, looking for the presence or absence of a mental illness. It would be unusual for someone to have a new onset mental illness that led to insanity right away, that they're not ever going to treatment. I suppose it's possible. So looking for their diagnosis in the past records, also substance abuse, also any evidence that they're antisocial. Then we look at, if they're available, psychiatric records close in time to the offense. Some defendants, may be in treatment in the time frame of the offense. Maybe they saw their psychiatrist that week or that month or their social worker. So we're going to see, were they having an exacerbation of the illness or not? That's very important information. Likewise, some defendants, whenever they're arrested, the officers recognize them as being ill and take them to the hospital. So those hospital records are very critical to reconstructing the defendant's mental state at the time of the offense. Then we look at all the accounts of what the defendant said or did during the offense, as given by the victim, by the witnesses, and by police. Again, trying to reconstruct the mental state, because basically what the defendant said or did, as evidenced by witness statements, indicates his mental state during the offense. We then do a personal interview of the defendant getting his account, and we put less weight on the account given, might be months later when we actually see the person for the sanity evaluation. But we're going to get that and get their rendition, both for the presence or absence of symptoms and looking at the motive for the offense. All right, so here we go again, the standard threshold of this term of art, the severe mental disease or defect. So courts have interpreted that as meaning, under the mental disease arm, psychotic disorders, mood disorders, and dementia and delirium, possibly post-traumatic stress disorder, possibly multiple personality disorder. Courts are split on this, but they have ruled that personality disorders do not qualify, voluntary intoxication with alcohol or drugs, and paraphilia. So someone can't be a pedophile and claim that they're insane for a child rape. Courts won't allow that. Likewise, on the mental defect, so having low intelligence, having an intellectual disability would constitute a mental defect for the purposes of insanity. Here's some conditions that would not qualify, so being a cross-dresser, bestiality, intoxication, all would not constitute the threshold of the mental disease or defect. And then to be insane, the symptoms of their mental disease or defect have to cause them to not know the wrongfulness of their actions at the time of the offense. So this term wrongfulness can mean different things. In some jurisdictions, it says legal wrongfulness only. Did the mental disease or defect cause the person to not know that their acts were illegal? Some jurisdictions state moral wrongfulness. And some, like Ohio, leave it up to the jury to determine what kind of wrongfulness standard to apply. So you can break down this, there's the illegal wrongfulness. You can break down moral wrongfulness even more to subjective moral standard or objective moral standard. So it just depends on the jurisdiction and how the jury interprets this language here. So how do we evaluate? Oh boy, it's real loud here. How do we evaluate their knowledge of wrongfulness? We look at what the defendant said or did at the time of the offense, and then we get their later account of the offense. Again, looking for the presence or absence of symptoms and a motive. So typical motives are anger, revenge, financial gain, sexual exploitation. So those are all rational motives that don't indicate the defendant was unable to know the wrongfulness. Whereas if they had some psychotic motive, which if true, the act would have been right, that would qualify for insanity. So for example, if I have someone who's, and this is one of the most common routes to insanity, a perceived paranoid self-defense. So if I think Haley here is transmitting fatal brain waves to me that are going to make my head explode in the next 30 seconds, and I go and punch her and say, "Stop those goddamn brain waves, you're killing me," and I'm charged with assault, well, I could be insane because I'm acting in perceived self-defense. That's a common route to insanity. So we also look at behavior here. So if they hide evidence, that would indicate knowledge of wrongfulness. They hide the weapon, whereas if they leave the weapon out in clear view. If they flee the scene and flee from police versus after I shake Haley, if I wait around for the police to come because I say, "Officer, she was trying to hurt me." That's very different than if I take off. Lying about the offense versus telling the truth is important. Refusing to cooperate with officers. What about the defendant who calls 911 post-defense? Now, some prosecutors will say that's strong evidence of knowledge of wrongfulness. And I would differentiate that because some defendants, after the offense happens, then realize that the victim needs help, or they realize, 30 seconds or a minute later that that the person needs help or something wrong has happened. That's different than their mental state at the exact instant of the offense. If the delusion were true, would the act be right? Is one way to assess this. So getting back to Haley here, if I thought Haley had stolen $10 out of my wallet, even though it wasn't true, it's a psychotic belief, and then if I went up and punched her based on that misbelief, even though it's a product of my mental illness, I couldn't be insane because it's not legally right to punch somebody for taking $10 out of your wallet. We then looked at, is there a rational motive, those motives I mentioned before, versus an overriding moral justification? Did the person believe they were doing the morally right thing? So an example of this would be someone that they know what they're doing is illegal, but they're trying to save mankind. So for example, the man I referenced before that killed his 3 children in 1984, he believed that he had to kill his children before sunrise. If he didn't kill their bodies, then they would go to hell forever. So he believed it was right for him to kill them where they could go to heaven. It was the morally right thing, as opposed to going to hell forever when the sun rose. So he had to override moral justification. Now, some people confuse prior planning with lack of insanity. They say, listen, this was planned out, so he can't be insane. And I would make the point here that this is not relevant. People who are paranoid sometimes plan out their self-defense over the course of days to weeks. So it's not really a relevant issue here. And this just talks about the standard if we have a bench trial in which a judge has made a ruling. The appellate court will only overturn that ruling where there's overwhelming and uncontradicted evidence to the contrary is arbitrarily ignored by the trial court. Now, this just shows you how on top of things I am here. This is a U.S. Supreme Court case that came out just on Monday. I'm just joking here. Let's see. So in a 5-4 decision in this case called McWilliams v. Dunn, the Supreme Court interpreted their prior ruling in a case called Ake v. Oklahoma. Now, the Ake case was from 1985, and the Ake court said that a defendant who pleads insanity, who cannot afford to hire his own expert opinion, the court must provide him with a sanity evaluation. As long as he meets the burden of production to show that there's some evidence that his mental state will be a fact at trial, the court must pay for and provide him with a sanity evaluation. And in Ohio, that's why we developed these Ohio Forensic Centers. So every defendant who raises the issue gets a sanity evaluation. So in the McWilliams case, they further interpreted their Ake ruling to say that the court must provide not only the evaluation, but the preparation and presentation of the defense. So they must provide a psychiatrist in a defendant, not only to evaluate, and it could be someone else, because maybe the evaluator concludes he's sane. Regardless, if he's still going to go to trial and pursue a defense of insanity, the court must provide him an expert to assist in the preparation and presentation of his insanity defense, which I think is very interesting here. Let's talk now about what happens after a finding of insanity. So, within 10 days after the trial court makes a finding of insanity, the trial court reconvenes to determine is the defendant committable? Is he civilly committable? So the trial court retains jurisdiction of the case. It's not transferred over to probate court. And almost everyone who's found to be legally insane is found to be committable. In fact, I've never actually heard of a case that it didn't happen. So the next issue is, what's the least restrictive treatment setting to both treat the defendant's mental illness and to protect the public from them? So it's interesting, there's a twofold reason for the commitment of NGRI equities. It's not just about treating the defendant, it's protecting the public from the defendant. So the vast majority are found to be committable and placed in the state hospital, and they can either go to the medium security hospital like North Coast or Heartland, or down to Columbus to the maximum security here. In the hospital, there are continuing violence risk assessments to determine what's the least restrictive setting to put them at within the hospital. So we want to treat their illness in an effort to minimize their risk of reoffending. And in Ohio, we've got a very low rate of NGRI reoffenders. It's less than 3%. And of those 3%, not all of them reoffend because of mental illness. Others just reoffend for non-mental health reasons. It's important to keep in mind, though, there is no conviction, therefore no punishment. We have to tell our hospital staff that. We are not here to punish this person, we are here to treat them only. So here's the standard for commitment. This is a 512 2.01. You're probably all familiar with this. This is a standard for the commitment of any person. So a threshold of mental illness, that's that legal term of art, mental illness now, which is defined in the statute as a disorder of thought, mood, orientation, perception, or memory that grossly impairs one of four things: the person's behavior, judgment, the capacity to recognize reality or meet the ordinary demands of life. And a mental illness has to cause one of these four things. So danger to the patient, danger to others. I'm sure Paul Friedman can quote this in your sleep, right? Yeah. They can't provide for their basic physical needs, and hospitalization is the least restrictive placement. Or they would benefit from hospitalization and their behavior infringes on the rights of themselves or others. So now for forensic patients, in addition to this standard for commitment that comes from the statute, we have a case called In re Burton from the Supreme Court of Ohio in 1984, in which the court expanded the test for commitment for forensic patients. Mr. Burton was a man who shot and killed a pizza clerk, either because she gave him the wrong change or a cold milkshake, or a cold pizza. I forget what the facts were, but anyway, he was found to be incompetent to stand trial, failed restoration, found to be unrestorable, and was in this kind of gray area. He was sufficiently ill enough to still be incompetent to stand trial, but not sufficiently ill to meet the statutory standard for commitment. He was going to be released. So the prosecution appealed that, and the Supreme Court of Ohio eventually developed the Burton standard for commitment, which is basically a totality of the circumstances test, that the court can order the commitment based on a consideration of the totality of the circumstances, which may include all these factors here. And it's interesting, some of these are historical factors. So is there a history of engaging in behavior that is a substantial risk of physical harm to himself or others? His present state, his person's insight into his condition, the grounds upon which the state relies for the commitment, history of conforming this behavior to the laws and values of society, and if their mental illness is presently in remission, what's the cause and degree of that and the probability the person will continue treatment. So if you have a person with a history of noncompliance and repeat episodes of mental illness, even though they're stable now, you could commit them under the Burton test. And this is what typically happens with forensic patients. So you have someone who is, I guess back to our question here, someone who's NGRI 20 years ago on a murder charge, who's still symptomatic, but doesn't meet 512 2.01, he's going to still stay in the hospital based on the Burton test, based on historical factors. Now, in the hospital, there's different levels of care. As I mentioned before, there's two different hospitals, either maximum security or medium security, or conditional release. So we talked about this before, about Twin Valley maximum security. So at the medium security, there's different levels of movement, anywhere from level 1, where they're always in a locked-in area, to level 5, where they can go off the hospital grounds with no escort. So a wide range in levels of movement here. And the way that we assess this is that there's multiple levels of violence risk assessment, starting with the treatment team. They do their own clinical violence risk assessment. They also administer a risk assessment tool called the HCR20. And they opine what if the person is ready for level 2 or 3 or 4 or whatever. Then there's the forensic review team, which is a panel of psychiatrists and psychologists that work for the hospital but are not directly involved in the patient's treatment. They do their own independent assessment. If they agree that the person is ready for an increase in privileges, it goes to the Chief of Forensic Services, or that'll be Dr. Stankowski at North Coast. If she approves it, then it goes to the court, except for if the request is for level 5 or conditional release, there's another independent evaluation that's done by the Forensic Center. So all these different levels with the idea that people won't get a higher level than they can safely handle. The trial court then has the ultimate decision on this, and the prosecution has a chance to object to it. So then we have conditional release, which is discharge from the hospital, but it's not an outright discharge, it's a conditional release. So they're released with tight control in tight conditions. So similar to someone being on probation. And they've got a very tight plan that if they violate any one condition of their release plan can be brought back in the hospital. I've had patients before who went out, were out for 6 months, they had 1 can of beer, got picked up, brought back in the hospital because we want to minimize the chance for reoffense. So some common conditions would be to require them to live in a group home, to keep all their appointments, to comply with all their treatment, not use alcohol or drugs, no weapons, no contact with the victim, etc. Now in the past, whenever the court was faced with one of these requests by the hospital for increase in privileges or conditional release, the trial court had discretion. Even if there was 4 medical opinions saying that level 5 is safe and no conflicting opinion, the trial court could still say no. Well, there was an appellate case then that changed that now has been incorporated into the statute. So the prosecution now has the burden of proving by clear and convincing evidence that the increased privilege level should not be granted because of a threat to public safety or safety of any person. So in theory, courts have less discretion. What really happens is courts say, well, we're going to do what we want to do and go ahead and appeal this. But that's not for here or there, I guess. So pretest question 4, yes, defendants who were found insane, even for murder, can be released back into society. But contrary to the public misperception that they're not followed up, that they frequently reoffend, that they stop their treatment, they're usually under very tight conditions, and we have a low rate of reoffense. And this gets to someone who's found to be insane is retained under the trial court jurisdiction for the length of time they could have served had they been convicted. So for a murder charge, obviously they're under the trial court's jurisdiction for life. For a lesser offense, there'll be some time limits on that. All right, so that is not guilty by reason of insanity in less than half an hour. Any questions about that? All right, so now let's talk about, just briefly, about psychiatric assistance for mitigation. And this comes under 2 different fashions. One is the court can make a referral for, was there any psychiatric factors in the offense? So this would be psychiatric factors that are not so severe as to constitute legal insanity, but still that the court would want to take into account as mitigation during sentencing. So for example, one time I had a woman with a history of depression, very severe depression, was in the hospital for treatment of a infected toe. And she came home, she lived with her boyfriend, and she came home to find the door locked, came home from the hospital, toe was all bound up. And guess who answered the door was her boyfriend's girlfriend. And the girlfriend slammed the door on her newly incised toe. So she struck out. I think she stabbed the girlfriend. So not legally insane, obviously, but depression. She had a serious depression going on. The sudden shock of seeing the new girlfriend on the scene, and of course getting her toe slammed, were all factors in the offense. And then courts might make a referral for psych recommendations. So if someone is granted probation, should some kind of mental health treatment be a condition of their probation? And in fact, in some counties, they actually have MDO programs, so mental disordered offender programs where they have specific POs who are trained in mental health issues, lower caseload, and they go see a psychiatrist who's experienced in forensic matters. Let's talk now about involuntary treatment, because this comes up in the context of competency and sanity patients. And to talk about it, let's first talk about informed consent, of which there are three elements of informed consent: information, competency, and voluntariness. You have to have all three to be present for a patient to give informed consent for treatment. So the first question is information. How much information about a proposed treatment should a doctor disclose to a patient in order to truly get informed consent? Here's Woody Allen thinking about that. So we have two different models. One is from 1960, the Nathanson v. Klein standard, where the Supreme Court of Kansas said that a doctor should disclose what a reasonable medical practitioner would disclose. So based on, I guess, the mental state of the physician. In contrast, we have Canterbury v. Spence, a U.S. Court of Appeals case, and they said, no, instead it's what a patient would believe to be material information, the materiality of the information standard. So you don't have to disclose all information about the risks and benefits of treatment, but instead what a reasonable patient would want to know. Second element is voluntariness, and basically patients cannot be coerced into accepting treatment. You can't say, if you don't take your medicine, we're not going to feed you lunch. That's coercion. Now you can, though, talk about the acceptance of medication can then lead to a decision about, are they ready for a level increase in the hospital for a higher privilege? Because if they don't take their medication, they're at a higher risk for relapse and therefore a higher risk for violence. That's certainly reasonable, but you basically can't be coercive. And the third thing then is competency. So you've seen the slide before, just about competency in general. So we're looking at the quality of their thinking. I try and not do this here. I don't medicate first and ask questions. I try and ask questions first, so I would advise against that. And I'm just going to skip through this here in a second here. Now there are different arguments for either forcing incompetent patients to accept treatment or letting them go untreated. So arguments that patients have a constitutionally based right to refuse treatment are based on privacy rights, that it's cruel and unusual punishment to make them take medication with all of the adverse side effects, and it's fundamentally unfair in violation of due process. And we see outside psychiatric conferences all the time protesters who are protesting the fact that, yes, sometimes courts and psychiatrists get involved in involuntary treatment. So drugs can kill, hurts people, no forced treatment. It's cruelty, torture, it's my body, no forced treatment ever. For no crime, don't make us do no psychiatric time. Some of this is from the Scientologists, by the way, but this is my favorite here. Psychiatry sucks, all right? Now, in contrast, you can say, well, listen, there's an argument that we should force treatment on incompetent people based on the parens patriae argument that the state has a role in stepping in and taking care of incompetent people, and also a police powers argument that we have a right, or we have obligation to step in when people are dangerous to themselves or others. So this only applies to voluntary or to involuntary patients. Voluntary patients have always had a right to refuse treatment except in an emergency. Now, prior to the 60s, if someone was found to be civilly committable, they also automatically lost their right to refuse treatment. But beginning with the 60s and early 70s, courts began to separate out these issues. So it's possible for someone now to be civilly committable and competently refuse medication. That happens on a not rare basis here. All right, so let me just go forward here, just in the interest of time here, and talk about the Ohio standard for involuntary treatment. You've got a summary of this case in your handout, the Steele decision from the Supreme Court of Ohio in 2000, which I think is a wonderful decision, because before this decision, different counties, different hospitals, different agencies had all different standards for involuntary treatment. So this is a very clear, well-written standard. It talks about the two scenarios in which involuntary treatment can take place. The question was really about, must a mentally ill person be dangerous for a court to order forced medication? And they answered that and said no. But they went on then to describe a three-part test for forced medication. And in the first scenario was in an emergency. So whenever there's a psychiatric emergency, a patient threatens violence or commits violence that would constitute imminent dangerous, then a psychiatrist, as a medical practitioner, makes a decision on the spot about imminent dangerousness. There's no less intrusive means of avoiding the harm other than the forced treatment, and the medication is medically appropriate. Now, in the absence of an emergency, we look at the patient's competency, and we go to court. So the court may authorize forced medications without dangerousness when the court finds there's clear and convincing evidence that the patient lacks the capacity to give or withhold informed consent, so they're incompetent, that the medication is in the patient's best interest, and no less intrusive method will address the person's mental illness. So to summarize here, non-emergency, court decision maker looking at competence and best interests. In an emergency, it's a medical professional judgment and requires dangerousness. So how do we do a competency evaluation for involuntary treatment? Here's the different factors we look at. They understand, first of all, that they're ill. Does the person understand that they are mentally ill? They understand the nature of their symptoms and the reason for the proposed treatment. Do they understand they've got a psychotic disorder and the doctor is prescribing a medication to treat their psychotic symptoms? Do they understand the benefits and the risks of the proposed treatment as well as any treatment alternatives? Then do they understand the prognosis with the treatment compared to the prognosis without treatment? So these are all things that we look at here. And I'm just going to fast forward through here. There's a lot of procedural safeguards put in place under the Steele case. But then we have this Cell decision from the U.S. Supreme Court in 2003 that talked about another. Do you have a question?
Could you tell us whether that decision-making is taking place in the general court, criminal court, or the probate court, or both?
The question is under Steele, is this decision-making, where we go here? Does it take place in the probate court or the trial court for a forensic patient? Both. So wherever the commitment resides, whether it's probate court or the trial court, that same judge would hear the issue about involuntary treatment. So Cell, let's talk about that for a second, is a different model for involuntary treatment. We have Dr. Cell, who was a dentist charged with, I believe, some Medicaid or Medicare fraud, who then in the context of his investigation then threatened the investigating FBI agent. So some serious charges. He was arrested and found to be incompetent to stand trial. So was sent to a federal correctional center for competency restoration. And he was in one of those narrow areas where, again, he was too sick, kind of like Burton. He was so sick to be incompetent to stand trial, but he was able to competently refuse medications. So he was going to sit there, kind of rot with his rights on, never go to trial. So the prosecution appealed that, and the Supreme Court said that, yes, Due process allows for forced antipsychotic medications solely to restore trial competency, but only under narrow circumstances. And they gave a list of 4 or 5 of these circumstances. There must be an important governmental interest at stake, in this case, to bring someone charged with serious crimes to trial. The involuntary medication must further the important governmental interest and likely to render him competent to stand trial. The medication is necessary to further those interests. It's medically appropriate. And they also said, listen, we prefer that you pursue involuntary treatment under the lack of capacity legal argument. But if that's not possible, then you can pursue it under this compelling governmental interest argument to bring a defendant who's charged with serious crimes to trial. So that gets to our pretest question 2, that can a defendant who's psychotic, who's incompetent for murder, he may refuse medication, yes, as long as it's a competent refusal, but then the prosecution can still seek to treat him involuntarily under a cell theory. Proceeding here towards the end here, let's talk about mental health courts. In this slide, and you might have seen this before, but this depicts in the mid-1950s the peak census of state hospitals in this country, over 500,000 people hospitalized, and then a 40-year period of deinstitutionalization brought about by a number of factors. So some changes in treatment, so first medications for psychosis, some laws passed in the 1960s, etc. So the point here is that all these people got put out of the hospital, but then we're left with then, where do those people go? Well, as we heard about this morning, they're in jails sometimes, they're in prisons, they're homeless, and that the prevalence of serious mental illness in the corrections population is 17%. Serious mentally ill have higher arrest rates when they are arrested, longer periods of incarceration, higher reoffense rates, and a limited access to health care. So that brings us to the topic of mental health courts, which in Dr. Munand's sequential intercept model, it's intercept 3. So under this model, you have a specially assigned judge with an interest and some training in mental health issues, who's got a smaller docket, and they focus not just on the legal issues and the prosecution of this, but rather more problem solving. So looking at non-legal issues like treatment and housing and entitlements. Trying to bring people together to hopefully arrange for this person's treatment. So it is new roles for the judge, attorneys, and the treatment system here. The first goal then is treatment for the patient, and the person has got a chance to voluntarily comply with treatment, to move them out of the jail to a treatment setting, and then once stable, then to return to court to enter the mental health court program. And Akron had the first mental health court in Ohio. It's a 2-year program involving intensive outpatient treatment. Multiple goals here, so compliance with treatment, to reduce reoffense rates, to encourage sobriety, to help the person obtain housing and employment. And the methods are diverse: case management, specially trained probation officers, treatment with psychiatrists, including medication management, and then frequent appearances before the judge to monitor their compliance. So the results are fewer jail bed days, fewer hospital bed days, lower costs, better outcomes of treatment, and lower rates of reoffense. So very successful. Then we have Ohio's new assisted outpatient treatment law, Senate Bill 43, that went into effect coming up on 3 years. So it expands the definition of a mentally ill person under the statute, under 512.2.01, that allows for court-ordered outpatient treatment. So you've seen this before. This is just the standard for commitment. This is a definition of mental illness that then must impair one of these 4 things. Well, now under this new law, there is number 5. So does a person have a mental illness, and then they would benefit from treatment as manifested by evidence of behavior that indicates all of the following. history of a lack of compliance without supervision, and one of the following applies: at least twice within the past 36 months, lack of compliance has been a significant factor in hospitalization, or within the past 48 months, the lack of compliance resulted in one or more acts of serious violence towards himself or others. The person is unlikely to voluntarily participate in necessary treatment, and in view of the person's treatment history and current behavior, the person is in need of treatment to prevent a relapse or deterioration that would likely result in a substantial risk of harm to themselves or to others. And finally, that they do not meet criteria under the first four for hospitalization. So that's Ohio's new assisted outpatient treatment standard, just in brief summary. And then finally, I'm going to finish up here with some factors, changing gears here, when you're in court dealing with mental health testimony. So typical things brought out on direct examination. I think I'm speaking to the choir here, but the expert's qualifications, the sources of information that were reviewed. In the event, I used a NGRI case as an example here. So you have the witness summarize the various accounts of the offense given by the police and the victim and the witnesses and defendant, and again, then give their opinions both on the diagnosis and then the legal standard for insanity. With respect to cross-examination, there's qualification challenges, and some things that typically get brought up are issues with licensure, so license discipline, board certification or lack of training in forensic psychiatry, have they got experience in this specific issue, have they published or done research or teaching on the specific issue that happens to be your case at hand, any honors and awards. On the methodology, we can challenge them on, did they look at insufficient sources of information? Was there documents or interviews that they should have looked at or conducted but failed to? Is there a lack of collateral data? Now, here's what's different between a forensic evaluation versus a clinical evaluation. If someone is seeking treatment, it's fine for the mental health professional to accept their self-reported symptoms at face value as accurate. It doesn't make sense for someone to come into treatment and to lie about their symptoms, because then they wouldn't get a proper diagnosis or treatment. But in a forensic evaluation, we don't use that methodology because we know there's the potential for malingering or exaggeration. So any good forensic evaluation needs corroboration of the person's self-report. So back to cross-examination here, if the professional simply took them at face value as accurate and didn't seek corroboration, that can be fodder for cross-examination. Also, if the expert is ignorant of the legal standard, it could be a flaw in your methodology. If they gave psychological testing but instead gave the wrong testing, if they ignored conflicting data. In most of these cases, all of the evidence isn't all on one side. It's usually 30-70 or 80-20. So if they ignored the conflicting data and failed to take it into account, that can be ripe for cross-examination. Fail to investigate a plausible alternative theory. So for example, in an insanity case, failure to investigate a potential rational motive versus a psychotic motive. You can challenge your opinion. Facts don't support the opinion. Leaps in logic, speculation, faulty reasoning, using the wrong legal standard. Level of certainty that they say something is probably or maybe, and that, of course, is not admissible. And then you can challenge your objectivity. You've got a bias or a vested interest in the outcome of the case. These 8 impeachment points are typical or kind of classic impeachment points for any kind of cross-examination. And the ones in red are ones that I think at least are more prone to apply to mental health professionals. So bias, interest, prejudice, prior inconsistent statements, or a bad reputation for telling the truth. And I'm going to finish up here, I think, with an example of this. Back to A Time to Kill.
certain. As certain of that as you are of the testimony you've just given before this jury?
Of course.
All right, so let me just understand this now. Since you are under oath, you're telling me and this jury that on October 17th, 1960, you were not convicted of statutory rape?
Objection, Your Honor. Facts are not on trial here.
Your Honor, this goes to the heart of the credibility of the witness.
Overruled. Continue.
Now, Doctor, were you convicted of statutory rape?
You got the wrong man.
Really? Well, I have some mighty interesting photographs of you taken with a female underage in a motel by the Dallas Police Department on September 11, 1960. Would you like to look at these visual images and see if they refresh your memory? No, I didn't think so. Your Honor, we would like to enter into evidence these court and police records showing that on September 15, 1960, this man, one Terrell Bass, pled guilty to statutory rape. Now, Doctor, I'm going to ask you one last time. Were you or were you not convicted of statutory rape?
Well, I can explain.
I'm not interested in your explanation, Doctor. Just answer the question, yes or no.
Yeah.
That's all right. I have nothing further, Your Honor.
All right, so obviously his prior felony convictions impeached his credibility with the jury in this case. All right, we've gotten through it. I think 210 slides in 2 hours. So, any questions? Way in the back there.
We found instances in mental health court when a defendant comes in for probation violation, and there's questions if they're competent enough, and so then he sent them to the clinic, and they're found incompetent. From my understanding, the statute is kind of unclear because they've already fled, and so I kind of wanted your opinion on that matter, and if they're not restored in that time frame, then kind of they're in this different world, and just kind of see what your thoughts are on that.
Yeah, I think you've pointed out a gap in the law. I believe the question is someone who's charged with a probation violation who's incompetent to stand trial, what's the time frame for restoration on their PV? And the statute is silent on that. So I can tell you at the hospital what we do or did is we just use the time frame for the original charge. And never had a problem with that and never had it challenged, but that's a gap in the law. Then the other question is what do you do if someone is incompetent and unrestorable, they fail restoration under PV, they would just be committed civilly through the probate court if they met that standard. Yes?
With regard to what Megan said as far as the time frame, so what happens then when we have a person who's originally charged with, say, an F4, they go to the hospital for restoration for the full 6 months, they are restored at the final hour, come in, plead, get put on probation, and now they're incompetent for a probation violation.
Right.
Didn't we already use the time that we had, or?
Good point. Yeah, and they've been locked up and lost their freedom for that time. Yeah, and again, the law is silent, but what I've seen courts do is they start anew. Or even to, I guess, take it one more step, what if you get a guy who's still pre-trial? He goes to the hospital, uses his full 6 months for restoration, gets restored, goes back to jail, and before he's tried becomes incompetent again. Do you start with a new 6 months? Law is silent.
Just to clarify something, post-NTRI, you said it's the trial court that obtains jurisdiction over determining whether or not the defendant is civilly committed. The prosecutor doesn't need to file the commitment proceeding with the probate court. It stays within the trial court.
Yeah, the case is retained within the trial court. Yes.
Doctor, in Cuyahoga County, there are 5 mental health docket judges. file isn't already tagged mental health docket, you can draw one of the other 30 judges. And then if you have it referred for a mental health court evaluation, it doesn't necessarily mean that one of those other 30 judges is going to consent to having the case transferred to one of the mental health court judges. Do you have an opinion on that? A lot of lawyers will try to judge shop that way.
Oh.
But, you know, some of the judges will be personally affronted that you want out of their courtroom.
Oh.
And their attitude is, I can handle this.
Just for the audience, the question is about there's 35 judges in Cuyahoga County, is that right? 36, whatever it is. So 5 are mental health court judges, the rest are not. So what if you get someone who's in a non-mental health court and the judge objects to the transfer to the mental health court? There's a standard for that, and the person can be referred to the court clinic for a mental health court evaluation. Standard is, do they have a psychotic disorder or a intellectual disability? So I would imagine you could challenge the non-transfer based on if you have testimony or a medical opinion to support the transfer. But I guess that's my only response. Yeah.
It would be real popular with that judge.
Well. Other questions? Yes, sir.
I believe part of the problem, in response to that gentleman's question, is that if you ask for a referral to the mental health court, that if the judge grants that that particular judge has to receive back 2 cases from you.
That's actually
That's
not
not.
true.
That's not true.
That's 100% accurate.
Has anyone else run into that?
They think that,
It's
judges
not.
think it.
Okay, judges think there's some kind of pejorative or some kind of something will happen. They'll get back 2 cases, but you're saying it's not accurate. Okay.
I can speak to both of those if you don't mind. That's a kind of an legend in our world. If a mental health judge receives a case, it's not going to, it's just one for one. And then the other question about if you can, if your judge doesn't want to transfer that case, it's part of our local rule that they don't, that there isn't a mandate that they have to. And the judges have to pass our local rules, and collectively the 34 of them have never put a mandate in the local rule that the cases can transfer. Some attorneys have challenged it with our administrative judge, but again, then you obviously have to outweigh if you're back in that courtroom that you challenge that is going to be negative appearance.
Okay. Great. Yeah, thanks for that information. Well, I see our time is up. Any questions, please shoot me an email, sgn3@case.edu. And there's a break now, right, to 2:15?
There is.
2:10? 2:10, all right. Thanks for your attention.
Maybe they'll be back at 2:15. Thank you very much.
Thank you.
I know that was a race.